Good afternoon, students. My name is Dr. Olatunde Olajide. Welcome to another weekly lecture on legal issues in management. Today, we are going to be having our lecture on the law of tort. The law of tort. Let me share my screen so that you can see my screen. Now, we want to look at what we mean by law of tort and how these can affect the relationship among people, individuals. Now, before I go into the detail of this lecture, it is important to understand that tort is an aspect of civil law. It is an aspect of civil law. So we are not going to be talking about anything related to criminal law in today's discussion. And should you require any assistance after this section, then you may book a personal tutorial with me. At the end of this lecture, you must be able to understand the tort of negligence. It is important to know that there are different aspects of tort. We have tort to person, tort to land, unlawful detention, and a lot of various aspects of tort. But today, our discussion is going to be on tort of negligence, which is basically an aspect of tort to person. So today, we'll be looking at, we'll be able to understand what negligence is all about. We'll be discussing about the elements of negligence, which is duty of care, breach of duty of care, causation, and the damage or losses arising out of breach of duty of negligence. Then we'll be looking at different judicial precedents that are applicable under the law of tort. To start with, what is law of tort? Like I said, law of tort is simply an aspect of civil law. It's simply a law that focuses on wrongful deed that is perpetrated against other people or people's property. So it has to do with relationship among people and how our action have effects on other people. So a tort is civil wrong, which is not breach of contract. So it's not contract. So, and there must be element of fault before you can be able to claim under the law of tort. Law of tort is also created by Act of Parliaments and judicial precedent. And it is based on the assumption or the evidence that there is a duty of care from one person to the other. And then the principal remedy for tort is to sue for damages. Not to send somebody to jail, is to sue for damages. So what is the purpose of tort law? Number one, it is a way of protecting people's physical and mental integrity, reputation and other personal integrity, ownership of property and undisturbed enjoyment. That's in the case of tort to land, which is equal trespass and nuisance, a part of tort to land, and then financial interest of people. Now, for somebody to claim under tort of negligence, negligence is simply failure to carry out an act or performing an act that should not be performed is one's responsibility to take care of another. So when you have a role to perform to safeguard somebody and you fail to perform that role, then you can be held negligent. Or you have performed roles that you're not supposed to perform, for someone you have a responsibility towards, then you could be held negligent. Now, for you to claim under the tort of negligence, there are 4 things that must be included. 1, you must be able to prove that you hold that person or that person owes you duty of care. You cannot claim that somebody is negligent towards you where the person does not owe you duty of care. Now, after you have established there's a duty of care, you must also be able to prove to the court that that duty of care has been breached by that person's action or inaction. Then you must be able to also establish a link between the injury that you have sustained and the breach. The fact that somebody has breached a duty of care does not mean that your injury is related to that breach. So you must be able to prove to the court that the injury you have sustained is actually as a result of the breach of the duty of care by this individual. Then you must be able to also claim that as a result of this injury, you have suffered damages. So if you are not able to prove any of these 4 elements of tort of negligence, you may be unable to sue or to get compensated for any suit you file under the law of tort. Now, let's consider the first issue. Is there a duty of care? How do you establish if there's duty of care? Now, the principle of duty of care was established in the case of Donohue versus Stevenson of 1932. In this case, there's what we call the principle of neighborhood, where it was decided by Lord Atkin, the presiding judge, that we all owe our neighbors duty of care. And the law went forward to define who is our neighbor. The court decided that a neighbor is anybody who can be affected by your action that should have been contemplated before you take a decision. It means that anybody that your action can affect is recognized as your neighbor under the doctrine of neighborhood as decided in the judicial precedents of Donohue versus Stevenson in 1932. However, it has been argued that the principle of neighborhood is too large. It means that everybody owes everybody in the world duty of care. But the case of Caparo Industries versus Dickman 1990 tried to narrow down the basic test that could be carried out in determining whether we owe somebody duty of care. And there are 3 tests. There are 3 tests that must be carried out before we can decide that we owe someone duty of care. According to Caparo Industry versus Dickman 1990. 1, for somebody to claim that it was owed duty of care, there must be what we call foreseeable proximity of harm. Reasonable foreseeability of harm. There must be reasonable foreseeability of harm. What does this mean? It means that the person carrying out that action should be able to know reasonably that his action is likely to cause harm. Should be able to know that his action is likely to cause harm. That's the first test. So when you want to take somebody to court to claim that the person owes you duty of care, you must first prove that the action this person has carried out, he should have reasonably known that it's likely to cause harm to me. 1. The second test is that if you look at the case of Home Office versus Dorset Church, you will get a detail of that. If you look at the second aspect, the second test is relationship proximity. There must be a close relationship between you and that person. Relationship could be in terms of space. It could be in terms of perception. So there must be a proximity that exists between you and that individual. That's another thing, test that must be carried out before we can establish that there is a duty of care. Then finally, it must be established that it is reasonable and fair to impose duty of care on that individual. If it is not reasonable, if somebody has the possibility of seeing that his action could cause harm and is in close relationship with another person, well, it is not just unreasonable to impose duty of care, then the person might not be able to prove in the court of law that the other owes him a duty of care. If you look at the case of Hill versus Chief Constable of West Yorkshire Police, 1989, it was decided that the police does not owe everybody duty of care because it is just unfair and unreasonable to expect that police will be able to take care of everybody in the country. So those three tests must be carried out to establish the possibility of duty of care. These are other areas whereby duty of care has been established. Generally, drivers are known to have duty of care for every road user, because of course, driver must know that if he drives dangerously, it can cause harm to all road users. And these road users are generally very close by space to these drivers. And also, it is fair to impose such. Manufacturers to consumer, like we see in the case of Donohue versus Stevenson in 1932, manufacturers must know that consumers, if they consume their goods and the good is dangerous, it can cause harm to them. And then there's already a relationship by perception to them. The employer owes employee duty of care because there's proximity. So an employer should know that if they do not make provision for health and safety equipment for employee, it could lead to harm. The owners of property to person inside the property, and a lot of them. Now, the second question is there any breach of duty? So this is a question of fact. You are showing that the defendant was in breach of the duty to take reasonable care and very negligent. So you must prove this, that the person has actually breached his duty to you. Many a times, there's different ways that we can see this. Many a times it's very, very obvious. It's very, very obvious that somebody has breached his duty of care. So sometimes the court will carry out further investigation to see that. So if you look at the case of Bottom versus Stone 1951, you will understand some of these principles. So for us to know whether somebody has dissipated reasonable care, we must consider the gravity of the harm that has been caused. So the more the likelihood of harm, the more the possibility of duty of care, as decided in the case of Paris versus Stephen Borough Council 1951. Then the cost of the precaution must also be taken into negligence. And you must understand that negligence is always judged from the point of view of the defendants, not of the plaintiff. And the standard of care is an objective one. So the third thing we want to talk about is when there is a causal link between the breach of duty and the harm and the injury sustained. So it's for what we apply is what we call the but-for test. And it's very simple. It's simply for you to show that if this has not happened, if A has not happened, then B wouldn't have happened. So you might be able to claim that, okay, if this fellow has not taken this action, I wouldn't have sustained this injury. So that is what is called but-for test. So but-for test is on the balance of probability. So that's Probably I wouldn't have sustained this injury if this person has not done this. And this has been decided in the case of Barnett versus Chelsea and Kesset Hospital, 1969. Now, if somebody has found guilty of negligence, are there any way out for this individual to defend this case of negligence? Or if somebody has been not really found guilty, or somebody has been taken to court on the ground of negligence, and it has been established as a duty of care, and a breach was caused by the the injury was caused as a result of breach. So what defense is available to the person who has been accused of negligence? One, voluntary non-fit injury. Voluntary non-fit injury simply means voluntary assumption of risk. Voluntary assumption of risk. For example, if somebody has domesticated a lion, he has a domesticated lion, and then somebody has come to visit and said, oh, I love your lion. I want to enter inside the same cage with the lion. And then the man said, no, don't try that. It's very dangerous. And he said, no, leave me. I want to tell you, I want to go on my own. I want to take that risk. The person has gone to Lion's Gate and anything has happened, it wouldn't be able to sue for negligence because it is a voluntary assumption of risk under the concept of voluntary non-fit injury. So we also have contributory negligence, whereby someone has also been part of the event that led to the negligence. For example, if you are supposed to have a seatbelt while driving, and then you refuse to do that, and somebody drove and you have an accident, so it will be, and you broke your back as a result of that accident, it will be concluded that even though this person is negligent, you have also made contribution. So it's going to reduce, it's not going to eliminate the act of the person who is found negligent, but it's going to reduce the damages that could be claimed under the tort of negligence. But the next one is what is called illegality, estoppel causa non oritur actu. So it means no action can be founded on a wicked act. So illegality can never become legality. Generally in law, there is a context in law that says that you cannot build legality on illegality. Ex nihili, nihili fit. Ex nihili, nihili fit. Simply that you cannot build something on nothing. So if the action is illegal and there's negligence, you cannot claim under the law of negligence. So I've discussed all this. So this is all about law of torts today. You may have to study some of the cases because law is based on judicial precedent and statute. And specifically, the law of tort is premised on statutory, on judicial precedent. There are a lot of cases for you to study. If you have any question regarding this, please contact me, as we shall be discussing some other very important aspects of legal aspect in management in our next section. Today, we have talked about tort of negligence. We have looked at how to establish negligence. Now we talk about the fact that there's various tests that must be carried out. We look at duty of care generally and look at what constitutes duty of care and how can we establish duty of care. We look at the case of Donoghue versus Stevenson 1932 to establish the neighborhood principle. And then we went forward to look at Caparo versus Dickman 1990. So look at the three tests that must be carried out before we can say we owe somebody duty of care. And then we look at how we could establish that there's a breach of duty of care. And finally, we concluded on the defenses that are available to somebody who have been accused of breach of duty of care under the tort of negligence. Thank you so much. See you some other time.